Hi, welcome to Educator.com. This will be our first lection in our course AP Government. It's going to be the foundations of the American Republic. So let's get started. So in today's lesson overview, we're going to describe the purposes of government. So what's the point of having government? We're going to identify the different forms and theories of government. We're going to discuss the various influence on American government in particular. What are the things that the founding fathers, what are the influence that they had when they constructed the Constitution? We're going to analyze the weaknesses of the Articles of Confederation. So why didn't that work? Why didn't the United States of America work under the Articles? We're going to compare the differences between the Virginia and the New Jersey plan. So these were the competing ideas on how the Constitution should be laid out. We're going to discuss how the Connecticut Compromise was reached. And finally, we're going to examine the process of ratification and the role of the Federalists and Anti-Federalists in constructing the Constitution of the United States. So these first two lectures are going to deal with the Constitution. In this first lecture, I'm going to deal a little bit more with the historical side and how the Constitution actually came into being. The second lecture, we're going to discuss a little bit more about what the principles were in terms of what's actually in the Constitution. Now, there's going to be obviously some overlap, but this would be the beginnings of the founding of the United States of America. So let's look at the preamble to give you an idea of what the Constitution was really about here. So let's dissect this together here. So we, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States. So this is the setup for what the Constitution is about. And again, this actually went through different drafts here. So we the people was actually the final product here instead of we the states or some version thereof here. So the whole idea of what the Constitution was, is it a collection of states or is it a collection of people? So in this introductory line, it basically answered that the United States is a collection of people and not necessarily states. Now, there's an aspect of that, but it is kind of interesting that the founders decided to stick with we the people of the United States of America. And again, the whole idea of a more perfect union, again, acknowledging, more perfect, acknowledging that maybe that they weren't there, but the whole goal is to create this perfect union. Establish justice. Okay, so justice, what is exactly meant by that here? So what are the boundaries? Again, this is the beginning part of the document, so open to debate here. Ensure domestic tranquility, so you have that aspect of it. Provide for the common defense. Again, these are things that are open to interpretation here, but provide for the general welfare. Again, this is probably something that over the course of time, in the context of the 20th century, what is the general welfare in the 21st century? What are the things that is allowed and not allowed in the Constitution? So that's the great debate. It's a matter of interpretation, and that's the beauty of politics, being able to interpret what the proper role of the federal government is, and secure the blessings of liberty to ourselves and our posterity. Do ordain and establish this Constitution for the United States of America. So the preamble basically sets the grounds of what the purpose of the Constitution is, and so we can analyze it even a little bit more here. So again, as I mentioned here, the early draft of the preamble included the states, but was eventually taken out. And again, it kind of represented that this document was supposed to come directly from the people rather than filtered through the states here. And at the same time, there's a creation of a federalist system of government, but that the ultimate authority is derived from the people. We the people. Again, a very common phrase in the United States. So if you grow up I think it's kind of interesting. If you grow up in the United States, most people think of themselves as Americans rather than as Californians or as Texans. Yeah, and it may be different depending on how much state pride you have. But again, the United States is considered to be more of a country rather than a collection of states, a country of individuals. So we have an interesting system of federalism that really isn't replicated in many other countries here. So again, the idea of establishing justice and ensure domestic tranquility, it's a matter of debate as to what that actually entails. Provide for the common defense. And again, another thing that a lot of people argue, what is the common defense? What are we actually protecting? That's a matter of hot debate in different contexts. Promote the general welfare. Well, the general welfare is this, what if providing for one group of people is going to come at the expense of another group, in terms of the rich at the expense of the poor, one group at the expense of another. And when you're dealing with women and children, what's the fine line here? Secure the blessings of liberty. Well, that's great, but when the founding fathers addressed this, securing the blessings of liberty, again, are we extending that to all groups of people or just white propertied men? So again, we'll see what the struggles were when the founding fathers came and created the American Constitution. So forms of government. So before we actually get into the actual government, let's look at the theoretical ideas of what type of governments exist and where does the United States fit in here. Anarchy, no government. Awesome. You don't do anything. There's no government. But the reality is that state of anarchy really isn't going to work out because the group that has the most power, the most guns, they're the ones that are going to take over. So anarchy, it theoretically is a form of government, but in practice, it doesn't really work out too well. Autocracy, rule by one. So human history has really been ruled by this type of idea. And there's absolute monarchy, constitutional monarchy, or a simple dictatorship. And so an absolute monarchy is basically a ruler who gains power through inheritance. There's no restriction on ruler's power. And basically the idea of divine right theory. A lot of kings in history are very convenient. They were king, they had power. Why? Because God gave them the power. And so this idea of an absolute monarchy, that's kind of been in existence throughout most of human history. Constitutional monarchy. Okay, this is inherited power with formal restrictions to the monarch. And usually constitutional monarchy, at least practiced in the UK, is basically a ceremonial power. So you have a Queen of England, but really the powers are restricted to being not really the chief executive, but you're the chief of state in the sense that you represent your people. So that's the type of constitutional monarchy that's probably practiced in a lot of modern countries today. But in the United States, we specifically made it a point not to have any sort of monarchy. Or finally, you have just dictatorship as the type of autocracy. This is where the ruler basically seizes power by force and restricts opposition forcefully. I guess it's very similar to an absolute monarchy, except the dictator doesn't call himself or herself a king. He just rules by force. And so those are the different types of autocratic governments. Obviously, the United States, we don't have a traditionally autocratic government. Another form of government that could exist out there is oligarchy, or rule by few. And different types would be aristocracy, ruled by the elites, which is usually determined by social status or wealth, or a theocracy, ruled by religious leaders. Again, just throwing that out there because these are different competing ideas on how government is run here. And finally, in the United States, we have democracy, ruled by the people. And so that's basically the type of government that most of the world will aspire to. And there's two different types of democracy. There's direct democracy and representative democracy. So what is that? Direct and representative. So direct democracy is where the citizens actually make decisions about laws. So this is the type of democracy where if there's 10 people, all 10 people decide. And with a small group of people, that might be fine and good. But what if you have 10,000 people? What if you have 10 million? Then the idea of having direct democracy becomes very inefficient and pretty ludicrous here. But even in the United States, in California in particular, there are examples of direct democracy happening. For example, there are propositions, referendums, and recalls in California. So this is where literally the people, rather than the legislature decide. So not only is there forms of elections, but in some states in the United States, you have more direct democracy. I would say in California, the examples of the people actually making decisions on laws, on gay marriage or abortion, or whether or not chicken should be transported with 14 inches of space while in transit. Some matters are really complicated, and American voters or California voters are deciding whether or not to implement this as part of the legal code. And so that's an example of direct democracy. But the more common type of democracy that we're going to see as practiced in the United States and by most countries is representative democracy. What is representative democracy? It's where citizens choose leaders who ultimately make decisions. So most countries, including the U.S., follow this type of democracy. So representative democracy or republic. This is really how democracy is practiced in the 21st century for the most part. You don't have individuals actually trying to have, in a country of 1 million people that's relatively small by the world standards, it'd just be so impractical to have everyone involved in terms of direct democracy. So democracy is generally seen to be as representative democracy. So the British clearly had influence on the American government. I would say the most important document is the Magna Carta. Okay. And so this was the first attempt to limit power of the British monarch by guaranteeing nobility trial by jury, due process of law, and taking of life, liberty, and property. So there is no British constitution. So the British Constitution is really just a collection of all the laws that have been implemented. Actually, one gag that I run with the social science department at my school is, if a student is getting a little bit rowdy or not paying attention, or if you want to pull a prank, that you could have a student go to another history teacher, and that teacher has got to be aware of this prank, is that get that student to get a copy of the British Constitution. And what you do is have that teacher refer that student to another teacher and basically bounce that teacher back and forth, preferably to one side of school to the other end of the school. Because guess what? There is no British Constitution. It does not exist. Whereas the United States, there's an actual constitution and amendments. There's no equivalent British Constitution. I guess the most equivalent might be the Magna Carta, but that's definitely not the Constitution. So again, if you're watching this, this might be something you might suggest to your teacher at school as a funny prank, or not. Parliament clearly was a means by which the British was able to influence the American way of government. So the Parliament actually began as an advisory group to the monarch, but eventually became the lawmaking body of Britain here. So you have a popularly elected House of Commons. Now, you might look at that and say, wow, House of Commons, that's very similar to the U.S. House of Representatives. And that's clearly where the House of Representatives was modeled from, the House of Commons. Okay. And you also have an appointed members of the House of Lords, which is kind of the upper body, and in the U.S. you see that being represented by the Senate. And keep in mind, the Senate was originally an appointed position by the state legislature. So this idea of this bicameral legislature was an idea adopted by the British. So, the United States of America, when they created the Constitution, there's a huge British influence. So even though Americans were breaking away from the British, it's only natural to have adopted a lot of the government ideas here. Now, to give you an idea of British government, the MPs, or the members of Parliament, they meet at the Palace of Westminster, which is the equivalent of Capitol Hill. And again, to me, it's a must-see tour if you visit London, England. I had the opportunity to recently visit London, England, and they give you a really extensive tour on Congress. So if you want a deeper understanding, or not of Congress, but of Parliament, if you want a really deeper understanding of American government, it's very helpful to go to where democracy happens in the UK, and you can kind of see where a lot of the policies and procedures were adopted by the American way of doing government. So the Enlightenment philosophers, they're also huge influences on the Founding Fathers. John Locke, the philosopher and not the character on Lost. I'm a big Lost fan myself. He came up with the idea of a social contract. So when people are born, they basically go into a voluntary agreement between the government and the governed. And he kind of postulated this idea that there's a social contract, that when people are born, they basically agree with the government to abide by this contract right here. Now, the reason why it's important is that, when you sign a contract, when you enter into a contract, both members are expected to adhere to the rules in the contract here. And so Locke postulated that there are certain natural rights, that people were born with natural rights such as life, liberty, and property. And so it could change their governments if these rights were violated. So this idea that if the government didn't respect these natural rights, so the British were not respecting the natural rights of the American colonists, then they had the idea to rebel. So in crafting a new constitution, this idea of natural rights, that there are certain God-given rights, was a very important concept in the beginnings of the Constitution. And Baron de Montesquieu, basically his major contribution to the Founding Fathers was that there was a need to break the government into three branches of government, which ended up being legislative, executive, and judicial. So, what are the three branches of government? You have a bicameral legislature, you have Congress, divided into the House of Representatives and the Senate. You have a singular executive branch, and you have a judiciary. So again, these are two of the philosophers that came in handy when deciding how to go about to crafting a constitution. So the Articles of Confederation. So before the Constitution, there's the Article of Confederation. So what's the history behind it? It was written by the Second Continental Congress in November of 1777. It actually lasted from 1781 to 1789. So, full 8 years basically, that united the colonies as a confederation. So you can say that it didn't work out here, but yeah, it was weak and maybe it required a new constitution. But, for the time, keep in mind the colonists had rebelled against central power and authority. So one could argue that this was necessary to see how a confederation of states simply wouldn't necessarily work. And so the Articles of Confederation, it had a weak national government with a unicameral legislature with basically no executive or judicial branch. So there was a president. In fact, you had individuals that were elected or appointed president. They weren't elected, but some didn't even bother to show up because it basically had no power. So technically, the first president of the United States, if you can call it that under the Articles, wasn't necessarily George Washington. George Washington was the first president as established by the U.S. Constitution. So that might be something that you might, pull out as trivia. Each state is equal to one vote. Okay, so you had 13 votes. Didn't matter the size. Each state was equal. So it was a collection of states and not necessarily of the people. And in order for laws to pass, 9 of 13 were required for laws to pass. So basically you had to have the supermajority agreeing on a set of laws. So it made it very difficult to get any legislation passed through using the articles. And not only that, amending the articles required a unanimous vote. So in order for there to be a new amendment to the Constitution, not 9, not 10, not 11, not 12, but all 13 states, or 13 of these League of States basically had to agree in order to amend the Constitution. So that would probably prove to be fairly troublesome. Again, more weaknesses of the Articles of Confederation here. Congress could not tax, I mean it could, but it would only request contributions from the states. So can you imagine that? The U.S. asked California, if you could please give us $10 million, we'd appreciate it. So you can expect there to be a lot of non-compliance or compliance only when it's convenient for you. They could not regulate interstate trade or foreign commerce. So there's no national authority to say to New York, to Pennsylvania in the case of a dispute. There was no central governing body. Not only that, there's no executive or judicial branch, which in terms of the power, all power is vested in the legislature. There was a mistrust in the authority of the king. So there's grievances against King George. So there was this idea that any power and again, the power wasn't even a whole lot, would be given to the legislative branch. There's no authority to coin money, so you had a problem. There's no national currency, so all these states were using various currencies. And again, population of states not taken into account. You had one state, one vote. New Jersey might love that idea. Small states love this idea, but large states, they were basically hurt by this. So, small states, small states were overrepresented basically. And large states were therefore underrepresented. So this was a problem in a country that was not yet united. And finally, 9 of 13 required to pass bills rather than majority. In addition to that, unanimous consent to amend articles rather than the 2/3 required by the Constitution. So when the articles were basically amended out of existence by the U.S. Constitution, a lot of these weaknesses of a 2/3 majority to pass the bill, a unanimity in order to amend the document, they were taken into account when the founding fathers decided, we're going to have a new set of rules to play by. So, the weaknesses of the articles served as kind of a jumping point as to what are the things that a stable, a thriving nation is going to need. So the Virginia Plan. So when they came up with this, these were the basic ideas that the Virginia Plan thought up to correct the defects of the Articles of Confederation. So the big thing here was a bicameral legislature, which I went over in England. They had this bicameral legislature. So this House of Lords and you have the House of Commons. So in the U.S., you'd have this lower house elected by the people, and you'd have an upper house chosen by the lower house from nominees submitted by state legislatures. So that was the kind of the big component of the Virginia Plan that improved on the legislature aspect of the Articles. And again, this was a key point that James Madison was really adamant about, and something that he did not like about the Senate that he felt would be undemocratic, is that representation is based on population. And as we know, the House of Representatives ended up becoming this kind of body, but the Virginia Plan was basically all about equal representation by the people, and so it was a collection more of the people. So the smaller states, they liked the arrangement of the Articles in that they were treated equally as a state. So a state like Delaware or New Jersey, as small states, the Virginia Plan was a threat to them because it equalized based on population and rather than by state. And the idea of having a single executive chosen by the legislative branch, limited to one term with veto power, but removed by Congress. So in the Virginia plan, the executive clearly is weaker than the executive that we have currently in our Constitution. But it's kind of interesting because at least Virginia did not view this executive as wielding a lot of power. So there's a lot of mistrust in giving too much power to one individual. Now, again, what's kind of interesting is that, this one individual, everyone basically knew that George Washington would eventually fill this post. But again, the founding fathers were probably thinking beyond George Washington. What do we do after the first president of the United States? And again, judges were chosen by legislative branch. So this separation of powers, this clear separation, was not really seen in the Virginia plan. And so the New Jersey plan was basically the alternative, the small state plan. So Virginia was this large state plan that helped large states because it was based on population. Well, there's some elements of the New Jersey plan that was basically incorporated into the Great Compromise, but this is what the New Jersey plan called for: a unicameral legislature, so just one body of Congress, so to speak, or one Congress, no split bicameral legislature. And in this unicameral legislature, representatives would be chosen by state legislatures, and each state would receives one vote here. And again, that was kind of a big sticking point in the New Jersey plan to give power and to empower the states. So representation equal among the states, no matter the population. Again, the small states want to protect the relative power that they wielded. You'd have a plural executive chosen by the legislative branch with no veto powers and can be removed by the states. So one commonality between the Virginia and the New Jersey plan was that you had a very weak executive branch, but you can argue that the New Jersey plan was even weaker because you had an executive, not only one executive, you had plural executives, but there's an aspect of federalism. The states wanted control of the executive branch here. Now, this is the element that actually survived through the Connecticut Compromise. Judges are appointed for life by the executive branch. So this is the idea that there should be some sort of independence of the executive branch, and that they're not chosen by Congress. So it's the President of the United States that actually chooses members of the Supreme Court. So the Connecticut Compromise, or the Great Compromise, was, exactly how it sounds. You took some elements of the New Jersey plan, mostly the Virginia plan, and again, they came up with something that was not necessarily perfect, but something that satisfied, contingents of both the small or the large states. If the Virginia plan proponents, if they didn't compromise at all, then the small states would have defected, and the small states clearly understood that they couldn't proceed unless the large states were involved. So this was the only way to really get them to agree to create a United States of America. So what were the elements of the Connecticut Compromise? Well, you had the bicameral legislature. You had the House of Representatives, which would be represented by population. And then you had the Senate, the upper house. And instead of one vote per state, you had 2 votes per state, or 2 per state. So that survives. So no matter how big the state is or small the state is, each state gets 2 senators. The House elected by the people, and the Senate, which was originally appointed by the state legislatures, and that survived up until the early 20th century, in which the 17th Amendment to the Constitution provided for direct election of senators. Probably out of a popular outcry, people wanted to be a little bit more involved in the process, so the 17th Amendment basically corrected for this defect. But again, this is not necessarily what the Founding Fathers wanted. Another thing was the idea of one executive with veto powers and unlimited terms of office, which later on was changed by the passing of the 22nd Amendment, which limits a president to 2 terms in office, or 10 years. So for example, a practical example here, John F. Kennedy, JFK, was assassinated on 11/22/1963. Okay. Again, most of you guys are watching this. If you're watching this, chances are you weren't born then. I wasn't born then. So actually, if you were living through this event, if somehow you were actually alive during this period of time, please make a point to make a comment and share your experience. But chances are, if you're 60 plus years old, you're probably not watching this lecture. But 1963. So Kennedy was our actually youngest elected president, not our youngest president, mind you. He was our youngest elected president. Now, a quiz question without looking online on Google. Who is our youngest ever president? And our youngest ever president was Theodore Roosevelt, because he actually took office upon the death of William McKinley. Again, the reason why I'm mentioning John F. Kennedy, well, he died in, shortly after his dying from having been shot by Lee Harvey Oswald. In 1963, well, he was elected in 1960, so he came into office in 1961. Now, he came into office in 1961, so he had already served more than half of his term. And so LBJ became president from 1964, and he served out the rest of the term. He got elected in 1964. And then so if he got elected again in 1968, which he dropped out of the race before at some point during the primaries, when he realized that because of the unpopularity of the Vietnam War, he didn't want to run for office. But if for some reason he did run, he would have been president for 9+ years. So is it possible for a president to be president for more than 2 terms? And absolutely the case. And so that's the example of a president serving 2 terms or 10 years. So if Kennedy had been assassinated in 1962, then he would have served less than half his term, and Lyndon Johnson would have only been eligible to serve 1 additional year in terms of election. But again, going back to the Connecticut Compromise, only 1 executive veto powers, and original intent of the Founding Fathers was, the president is an elected office, so if he wants to run more and more, then there's really no constitutional way of stopping him, again, until the passage of the 22nd Amendment. And another feature that was borrowed more from the New Jersey plan was the idea of a Supreme Court appointed to a life term confirmed by the Senate. So this is the idea of separation of powers and checks and balances all coming together. So what came out of the Connecticut Compromise was a lot of debate, a lot of pros and cons, and a lot of people that were maybe unhappy with one provision, but ultimately it's a document that's basically has survived for a really long time. And so the big elephant in the room, you're dealing with a country that was based on freedom and equality. And the big elephant in the room is that the issue of slavery, and again, the irony of it, was all not addressed at all. Now, again, a lot of historians argue that if it was mentioned, the South would balk and leave. So if the North insisted on the South, freeing slaves, and there would be no United States of America. Again, it's hard to, in retrospect, it's easy to say a lot of different things, but that's just the reality of what was going on. Slavery was a big issue. And so how did the Founding Fathers deal with the issue of slavery? Now, interestingly enough, I guess if you don't really think too deeply about it, you would think that the Southern states would say that slaves are property and shouldn't be counted as people. Well, the Southerners actually argued the opposite, and it was very logical. So the Southern states, they lobbied for slaves to be counted for representation And the Northerners, generally the northern states that wanted slaves to be, maybe not equal to non-slaves, but, you would think that the northern states would want that, but they did not. They did not want slaves to be representation because, if you added slaves as part of the population, then they would be represented even more in the House of Representatives. And if they weren't represented at all, then the Northerners would benefit because they would have relatively a higher percentage of representation in the House. And so basically what ended up happening was, I don't know why the origin of the, why it was a 3/5 amount seemed somewhat prudent. 3/5 compromise. Slaves would count as 3/5 a person in determining representation. Now, nowhere in the Constitution did it say that slaves were represented. So basically, they were referred to as other non-citizens, so to speak. So basically, it was understood that the slaves would be counted as 3/5 a person. Were the Southerners happy? I mean, they were probably 3/5 happy. Were the Northerners happy? They were probably 2/5 happy. So it was a compromise that basically sowed the seeds for a future civil war, but that's for a different lecture. Another compromise that was made was with the Commerce and Slave Trade Compromise. So this had to do with slavery. So Congress basically banned from banning the slave trade for 20 years. So eventually the slave trade would be banned, but for at least 20 years, Congress could do nothing about banning the slave trade. So the ratification of the Constitution. So it's all good that, the states wanted it, but did all the states want it? And, how many states would be required in order to get this ratified here? So it's kind of interesting as to, how to get support for this new Constitution. Well, the delegates signed the Constitution on September 17th, 1787. So they represent each of the states, but it technically didn't go into effect. So according to the rules of the Constitution, 9 of the 13 states had to ratify it before going into effect. Now, if the Constitution was amending the Articles of Confederation out of existence, then according to the Articles of Confederation, all the states basically had to agree to it. So even though it was said that 9 of the 13 states were required to ratify before going into effect, according to the provisions of the yet unpassed Constitution, really, if you had one state, if you had Rhode Island or Delaware or New Jersey refusing to sign, then you would have had a problem. But eventually all of the states did end up signing. So, when the, Constitution actually went into effect, to use the 9th state or 13th state, most historians will go for the 9th state. Those that were leading the charge that this Constitution was something that was really good and that was going to be in the best interests of the young country were the Federalists, and they were led by James Madison, Alexander Hamilton, and John Jay. And as a trio, they wrote as under the pen name Publius. Okay, and they favored ratification of the Constitution. So they preferred this idea that the government really should, have some national authority, and so they wrote a series of articles under the pen name Publius, and they argued for the merits of the Constitution and how a large republic was a good thing, and the measures enacted by the Constitution, they worked really well, and so this is what the Federalists argued. Now, not everyone wanted the ratification of the Constitution, so the Anti-Federalists, led by Patrick Henry, Sam Adams, and Richard Henry Lee, they all opposed the Constitution, and they wanted strong state government. So they wrote under the name not Publius, but Brutus. So back then they didn't use their names. They tried to use the force of their argument to convince the population, and so they didn't write their names. But I think over the course of analyzing the writing styles, we can figure out which of the individuals wrote which aspect of the Federalist Papers. And turns out Alexander Hamilton, he was one of the leading. Actually, James Madison and Alexander Hamilton, they were leading writers, but again, they don't want to trade based on their name. They want to trade off to the force of their argument. So the Federalist Papers. So what were the Federalist Papers? So the Federalist Papers defended the new government, published in the New York papers under Publius, and they eventually won public support for the Constitution. So people basically, they may have been hesitant in the beginning. What is this new Constitution? But Publius successfully argued that this was maybe in the best interests of the country. The major problem was that there was a lack of Bill of Rights, and that was a major concern for anti-federalists, along with too strong of a national government. So these were basically the huge concerns. So the Constitution was signed maybe with the idea that there would be a Bill of Rights, but a lot of the founding fathers maybe felt that the Bill of Rights that the states had were sufficient to protect individuals against too strong a central government. And the anti-federalists said that that's not enough, that they wanted a Bill of Rights. They wanted a Bill of Rights, and again, the idea of the government that was enacted, it was a little bit too strong for the tastes of the anti-federalists. And again, the reality was that the convention ended with no guarantee of a Bill of Rights. So it was talked about, but not necessarily guaranteed. Now, what ended up basically crushing the anti-federalists was that eventually the Federalists supported a Bill of Rights, as basically ensured that no new convention was going to be called to undermine the current Constitution. So ironically, the anti-federalists ended up opposing a Bill of Rights towards the end, because by supporting the Bill of Rights, the Federalists basically conceded the maybe defects of the current Constitution, and thereby enhanced the standing of the Constitution as it was written. And eventually, 10 out of the 12 amendments made it through Congress. So the Bill of Rights that we have today, the 10 Bill of Rights, originally 12 were adopted. The one dealing with House representation and one dealing with congressional pay actually failed to pass. Now, what's kind of interesting is that many years later, so this congressional pay amendment that never was ratified, it was actually passed by Congress, but it was not ratified. But the 27th Amendment, it was ratified in the early 1990s. So the time between proposing the amendment and ratifying, actually, the time that elapsed was 200 years. So that was kind of an interesting situation. There's no time limit regarding the difference between when an amendment is proposed through Congress and it's ratified. So the 27th Amendment, our most recent amendment that was passed, was actually proposed in the 1790s and ratified in the early 1990s. So example number 1. So let's go over some review questions here. Which of the following was not one of the reasons for the calling of the Constitution? So what were some of the reasons why the Constitutional Convention was called? If it was a reason, then we can cross it out. Okay, so make sure you're able to follow along here. Was there a need to regulate interstate commerce? Absolutely. There's definitely a need to regulate interstate commerce. States, when they're getting into disputes, the national government had no power to arbitrate. The Shays Rebellion in Massachusetts. Well, this is another way of saying that there was no strong executive to quell rebellions. The need for a stronger national government. Again, this is B and C are basically essentially saying the same thing. There's no protocol for dealing with situations. The national government didn't have the power to tax. They could request. So they were, in essence, very emasculated. The need to protect individual civil liberties. This one's kind of tricky because this happened after the Constitutional Convention convened. There's idea that there was too strong of a national government. So after the Constitutional Convention finished meeting, there's a group of people that said that there was a need to protect individual civil liberties, but the need to protect individual civil liberties did not lead to the calling of the Constitutional Convention. So this is correct in the sense of what happened after the Constitutional Convention, but is incorrect in that it did not lead to the calling of the Constitutional Convention. To correct the defects of the Articles of Confederation? Absolutely. So this was, a form of this question actually, I'm sure has appeared in the AP exam. What they're trying to test you is, do you know why the Constitution was called? What were the reasons? And basically you can spout out a list of different things. The Shays Rebellion, lack of power of the federal government, the Articles of Confederation was a league of a friendship league and not a nation united by the people. And then after the convention, there's a group of anti-federalists that wanted a Bill of Rights, and there was no Bill of Rights that was guaranteed after the passing of the Constitution. Another question here: which compromise issue addressed the issue of slavery? Excuse me. The issue of slavery, again, the elephant in the room here. Was it the Virginia Plan? No, not the Virginia Plan. What did the Virginia Plan do? That was the large state plan that basically wanted to give representation based on population. Was it the New Jersey Plan? No. The New Jersey Plan was a small state plan where you had one state, one vote. Was it the Connecticut Compromise? No. The Connecticut Compromise or the Sherman Compromise or the Great Compromise. These are basically saying the same thing. The Connecticut is the Great Compromise. That's basically what resulted in the Constitution that we have in a House, in a Senate, in a single executive, a Supreme Court. This is basically what ended up happening. So the slavery issue was resolved temporarily with the 3/5 compromise. So all non-citizen people, individuals, so basically slaves, they would be counted as 3/5 of a person. Thank you for watching Educator.com.